Non-usable sales. This is the one part that I'm going to talk about that is really New Jersey based. Most of everything else is going to be applied to anywhere and any kind of courtroom. In New Jersey, we have these non-usable categories. These are for sale ratio purposes. It really has nothing to do with a tax appeal and whether a sale is usable for court. It has to do with whether or not it's usable to determine a ratio for a whole lot of other reasons. Certain examples, and I could go through the whole list, but in NU6, all that means is part of the property was subdivided off. So they can't figure out the ratio from assessment to the sales price because the assessment was on the whole property and they just subdivided a half an acre. If you're appraising a half an acre, an NU6 sale of a half an acre might be the most usable sale as long as you verify that it's arm's length, it's exposed to the market, not under duress. Same thing with an NU7. I remember once I was appraising a new house, and in New Jersey, an NU7 basically is a code they give to new houses. The reason they give it an NU7 is when the house is built, they don't have an improvement assessment on it, so they can't figure out the ratio yet. It's land only. And I was told by somebody at an assessor's office who worked for the assessor that I couldn't even look at the NU7s because they're not usable. And I tried to explain that those were the only usable sales you can use for a new house. Again, you still have to do the normal verification. We have things like NU10s. There's a certain presumption that a sale by a guardian or a trustee might not be exposed to the market. They might have sold it quickly. There might be duress. And that all might be true. These codes are often something to help you, give you an idea there might be something there. You still need to do your own verification because sometimes it's some family trust. They've owned it for 30 years. They put it on the market. They're trying to get as much money as possible. If you get all that information, then most likely the judge will allow that sale in, as opposed to a sale that maybe was on the market for a week and unloaded. So you have to do the same research you do if you didn't have the NU. At least this helps you know what questions to ask for.
And Chuck, on that, I hear a lot of attorneys come into court and say that was an NU sale by the assessor, it can't be used. That is not correct. Chuck is absolutely correct that what you've got to do is you've got to verify that information. It may take a more detailed due diligence because you're coming up with someone else already having said they didn't want to use it. But as Chuck says, that's for sales study purposes. So you can use those sales. They can be very good sales and very good market indicators. They just were not used by the assessor for other purposes. And if you hear your attorney say, well, you can't use that sale, it was NU, speak with the attorney and educate them because they need to be educated for that purpose.
An NU23 means there's like machinery or fixtures included. You will typically see that with a sale of a restaurant. If all sales of restaurants are NU23s, and if you're going to use, and this is even if you weren't going to for a tax appeal for some other purpose, as long as they're arm's length and exposed to the market, restaurants come with kitchens and kitchen equipment, and they're probably a usable sale if they meet the definition of market value. You'll see this NU26. There's some other reason.
That's my favorite.
There might be a really good reason. So you got to talk to the broker, talk to the buyer or seller, talk to the attorneys, and there might be some reason that it is just the assessor wants to get rid of it. It looks like it's an aberration, but they're just suspicious, but they might not really have a reason. If you use that sale and you do your due diligence and you talk to the attorney and the buyer or the broker, now what will happen is you're going to get that sale in unless the other side can come up with the reasons why it really wasn't a good sale.
There's a question.
Are non-usable sales specific to New Jersey, or is this universally true to all states?
They're specific to New Jersey, but some of the reasons why you can't use those sales are the same reasons like a bank sale, a sheriff sale, between related parties, although it's not called non-usable. You couldn't use some of the non-usable categories in any state because they're not arm's length. The codes are New Jersey. The codes are just New Jersey. NU31, first sale after a foreclosure. I had a case recently, and this affects just appraising residential properties, not for a tax appeal. There's a lot of controversy whether banks will let you use those sales, not let you use those sales. The Appraisal Foundation came out with something in May 2012. And basically they said some people think you can't use comparable sales that were bank-owned properties or short sales, and they should not be used as comparable sales. The Appraisal Foundation said that might be true In some markets, those might be really the only sales that there are. I had a case in Plainfield. My subject was a short sale. It was boarded up. It was a 4-family. They weren't going to settle with us. I gave the other side this position paper by the Appraisal Foundation, and then we said, look, there are 27 short sales there are 27 4-family sales in 2009 in Plainfield, and 25 were short sales. That, our argument was, that is the market. Here's some authority that maybe if it is the market, you can use it. And we had the added luxury is if I can't use a boarded up sale and my subject's a boarded up property, then there are no comparables left. Never got to find out, that we settled. It wasn't a big matter, but what our position was, we'd be happy to litigate that legal issue. At least we started to have some authority. So when you're doing things for a tax appeal, sometimes you're told you can't do this, you can't do that. That might be true, but you might be the next one to prove to a judge or just to the other side that you might have a plausible argument. If you do your research and you find other sources, well, maybe you can. Maybe it does make sense. This was an example where they decided, well, at least with us, to settle that short sales counted.
Chuck, just on that point, there's a conference that I go to of state tax court judges. And this year it was held out in San Francisco. And that very issue was hotly discussed by other tax court judges throughout the United States. What is the sale? Is it a good sale? Is that the only sale? And the judges from Chicago and Detroit, there are large portions of those cities that are the only sales. And they really are now becoming the market for that area. And the second sale of those properties really is not showing a large increase in value. Yes, they do some fit up and clean up to it, but the second sale is not showing that the first sale was wrong. They're not good. So it's an area that we as judges are looking at and studying and seeing which way we're going to come. And you as appraisers are going to have to educate us so that we know what the market is and that the values that are coming in those sales really represent market value.
One of the things that was interesting in Plainfield, these sales were in the $150,000 range. And most of them had sold in 2007, $350,000 to $400,000. And those were the last, quote, good usable sales. I suspect a lot of those were really mortgage fraud and all sorts of things going on in that market, and that those really are probably the sales that should have been non-usable. But they were trying to hang their hat on that for a while.
That's the question. Which is the good sale? Was it, as Chuck says, the $300,000 sale or the $150,000 sale?
One of the questions that I would raise is that if you are going to use short sales, how would you tackle the market value definition?
That's a great question. So some short sales, and here's some of the distinction. How long did they own it? How well was it marketed? If it was on the market for 3 months, and most properties were on the market for 3 months, and it was with a regular broker, and they weren't just trying to do a liquidation sale, they were still trying to get as much as they could for it. Those are the kinds of things you're trying to show that it meets the definition of market value. If they sold it in a day and you talk to people and they said, well, we just wanted to get rid of it. We're not in the, so they're fact specific, which is one of the things that I had said earlier, facts win cases. If you can demonstrate how long things are marketed in that market, and this was marketed the normal amount of days that most properties are, then you more likely can meet that definition of market value. There's probably not duress involved, but you got to be able to show the bank's really trying to get as much as they can. If they sold it in a day to the first person who made an offer and it was nowhere close to the asking price. A lot of markets, the MLS will say most things sell, I'll make up a number, 90% within the asking price. And your example, it sold 25% of the asking price. You might have a problem. So it's those kinds of facts that you're trying to show. Yes?
This misconception about a bank short sale, all that really means is that the bank is the one who's ultimately taking the haircut. It still means that sale could be good at that price. And most of the lenders really know what the value is unless the real estate agent is being unscrupulous and is selling to a friend. But the typical short sale, in my market area, we don't have a lot of them in certain towns, but I'll look at it and I
you have a good point, and it brings me up to a slide I haven't gotten to yet. But a lot of times I will hear from appraisers, I'm reviewing an appraisal, and there's information they don't use because they heard they can't use it. So if you said, well, I can't use a bank sale, well, you can. You're the appraiser. You do what you think is right. You might not want to only rely on that in case that sale gets thrown out, or you might not necessarily want to put the most weight in a sale that you haven't done all your verification. I remember I once I had to do a log cabin in Sussex County when I was a young appraiser. And that was one log cabin sale. I was amazed I could find it. It was in the same county. After that, I was using Cape Cods. I could verify all the sales but the log cabin. Well, the log cabin sale, it was the best sale, but I couldn't verify it. So I knew there was a strong likelihood it could get knocked out. So I didn't not use it because I didn't verify it. I wanted to be able to talk about it. I knew when they asked me, did you verify it, I was going to say, you know, I couldn't get the attorney to return my calls. I couldn't get anybody to talk to me. But I still wanted to be able to talk about it. Then it goes to how much weight, if any, the sale will be given. But I knew as an appraiser, if I didn't use that log cabin sale, you know, it was going to be used against me anyway. I mean, I didn't use it, and they were going to say, Mr. Blau, how'd you miss the log cabin sale? So, you know, use what you think is right. Don't not use it because someone said, I might not be able to use it, which is somewhere, now will be a slide we'll be able to go faster on.